Okay, it looks like we have a majority of our folks in here. So welcome everyone to this eviction prevention training during a COVID-19 world. I'm Tony Curtis. I'm the development director with the Metropolitan Housing Coalition. We facilitate research-based advocacy for fair and affordable housing in Louisville. One of our big publications is the State of Metropolitan Housing Report every year. And so we're right in the middle of this eviction work, right along with a lot of our colleagues who are here as panelists and you as attendees as well. So thanks for taking some time to come out and join us for this discussion. Just a couple tech issues before we get started. The chat session will be open at all times, so we encourage you to have some good discussion there. And also for questions, if you have questions for the panel, there's a Q&A button at the bottom of your screen. If you mouse over the screen, you'll see Q&A. Just type your question in there, and we're going to reserve the last 15 minutes today for questions from everyone who is attending. So just use the Q&A function, and we'll get to those questions as well. And we are recording this today so that we can make use of it to a broader audience. So just wanted to let you know about that as well. So let's do introductions, and if our panelists would do self-introductions, I would like them to also address this question. What keeps you interested and innovating in the work for eviction prevention in this COVID-19 world? What keeps you coming back to it every day to work for people? So Ben, you are unmuted. Would you start?
Okay. My name is Ben Carter. I'm an attorney with an organization that works statewide called the Kentucky Equal Justice Center. We work with our legal aid partners that provide direct services all across Kentucky. And we sort of work on the systems stuff. So we work in Frankfurt on legislative matters, as well as doing some class action work that legal aid organizations are not allowed to do under their restrictions. So I'm here because part of our mandate is to help legal aid organizations do the very best job that they can for their clients, and so that's how I got into this. I used to work at Legal Aid Society. I want to disclose that I've never once defended an eviction. So there are people in this room with much more expertise than me on that particular matter. It's just I've been tracking sort of the CARES Act and recent developments.
John?
My name's John Young. I'm the intake manager at the Legal Aid Society. I've been with Legal Aid for going on 20 years. I've done evictions a long time ago. As intake manager, I have to know a little bit about a lot of different things. And so I know a little bit about eviction. I've had some help in answering these questions from Stuart Pope, and thank you, Stuart Pope, for your help. What keeps me going is that I have to. We have our client community is depending on us to get them through this.
Thank you, John. And Tonia.
Thank you for having me today. I'm Tonia Nolden. I'm a prevention and diversion coordinator, that's a mouthful, with the Coalition for the Homeless here in Louisville. Just to give you a quick breakdown of what prevention and diversion means. Prevention, what we do in that space is we help people maintain their homes, and that's where this eviction piece comes in for us. We don't want people losing their permanent housing in any way, so we need to connect to resources, even do some landlord mediation to assist in maintaining a person's home. And the diversion side of this work is that if a person has lost their home for whatever reason, we want to do what we need to do to get them back to permanent housing and avoid or divert from entering the shelter systems. And I do that work with not only individuals, but families as well. So in a nutshell, that's my role at the Coalition for the Homeless. I've done this work now for 2 years. This program was implemented, prevention and diversion, 2 years ago on the day I started. Prior to doing this work with the coalition, I used to be a domestic violence advocate with the Center for Women and Families. A lot of the work I did there was not only in their shelter and answering hotline calls and being an advocate in those spaces, but as well as doing work specifically in the 40210 area code here in Louisville. So that's working with people in Algonquin, the Parkway Place, those folks in those areas needing assistance with not only any danger they were facing and by the way of domestic violence, but also still connecting people to resources. So I bring that expertise into the prevention and diversion realm. And again, we want to focus on keeping people safe and in their homes, away from danger as much as possible. And that's what motivates me every day. That's why I do this work.
Very good. Thank you very much. Well, just also a quick shout out to Claire Wallace here for inviting me to moderate today. As MHC that's one of our roles as a coalition is to convene public at public forums, public meetings, and facilitate discussions. So this is a timely and very important discussion for us to have as a community. So let's start out with kind of a discussion of some common red flags from landlords who are misbehaving and that are grounds to receive legal support. Incomplete letters, maintenance. What can someone address that issue?
Sure. You know, some common red flags for a bad landlord is a landlord who is refusing to make repairs on a place, right? They're more worried about the bottom line than the well-being of the tenant. A refusal to accept rent payments that are offered in a timely manner. Threats to terminate the lease or set the tenant out without providing proper notice or filing an eviction. So an illegal lockout, disconnection of utilities or other services, or citing the tenant for petty offenses or things that the tenant did not do.
Very good. Any other thoughts? And let's think about late fees. So you mentioned late fees. Are there legal grounds to push back against high late fees or any fees of any kind offered from the landlord?
Well, I mean, so late fees are usually set out in the lease. Usually the tenant and the landlord, they have contracted for them, right? But those late fees, they must be reasonable and reasonably related to the damage suffered by the landlord. You know, if they're too high, one can argue to a judge later, look, this is just way too high, right? My rent is $500 a month, and my landlord is saying I owe $500 in late fees when I'm 5 days late, right? I think everybody can agree that just is unreasonable. There's no bright line rule of what is reasonable and what isn't. Reasonable is in the eye of the district court judge hearing the case.
And so to sort of piggyback on that, what I would say is, like, for practitioners, like people who are working at Family Health Center or something like that, you know, there's a cost to disputing late fees in the sense that you have to risk going in front of a district court judge and arguing that these late fees are too high, which takes time, it takes energy, it takes a lawyer. There was a recent Kentucky Court of Appeals opinion that upheld a Fayette district court judge's finding that 20% late fees that were in excess of 20% was unconscionable under Kentucky law. So the judge hearing the case in Fayette County said these late fees total more than 20% of the entire rent amount, and I find that unconscionable. The Court of Appeals upheld the finding that that was too much in rent. So there is no bright line rule, but we do have that Court of Appeals decision. The step one, though, is finding a judge in Jefferson County. Each judge is different, to agree with that Fayette County judge that 20% is too high. It may be lower than that. It may be 10%. You know, if your rent is $500, is it $50 late fee is unconscionable? Probably not. But we do have a 20% ruling being upheld at the Kentucky Court of Appeals. And, you know, late fees are a different matter now as well in the pandemic, because the CARES Act prohibits certain landlords who are who own what's called covered property from even charging late fees. And sometimes it's easy to tell whether a landlord is prohibited, because if your client has a housing voucher or lives in a property that has low-income housing tax credit or something like that, that's a covered property. Other times it's going to be more difficult, because any loan that is backed by Fannie Mae, Freddie Mac, or the FHA is also prohibited from charging late fees. But it's hard for tenants and their social workers to know which properties are covered and which properties are not covered. So you need to sort of ask your landlord to do the investigation.
One thing I wanted to add about late fees as it relates to the work from a social work perspective. Again, in the work that we're doing at the coalition on the prevention, the eviction prevention side, we do some landlord mediation. So just to give you an example, if a client reaches out to us for assistance in paying their rent, there's some steps that we're going to take before we get to an amount that we truly need to send to this landlord. One of those steps will be to understand how much is really due at this point, get a good breakdown of that. You know, are we looking at 2 months past due rent and $100 in late fees in addition to court costs? And then we try to do in some of that mediation, negotiate the late fees. Now that this client has reached out to an organization like mine for help, Mr. or Ms. Landlord, is it possible for you to consider waiving the late fees in this case? In most cases, they will waive the late fee. I think a lot of folks don't realize that some of these things are negotiable before we get to a situation where we have to go to court. There's some things we could do in the front end. If this client has a really good rent history, in a lot of cases, they're like, yeah, I'll waive those fees, no problem. In some rare cases, there may be a situation where the landlord's not in agreement with waiving anything. You know, Tonia, I appreciate you doing the work you're doing. You know, I'm all for it, but not with this client, I will not. And we just have to respect that and you know, work with what we have at that point. But again, as it relates to late fees from, again, a social services perspective, these things are negotiable. It does not hurt to ask the landlord to consider waiving a late fee if we have to. So hope that helps folks. Just ask, doesn't hurt to ask.
Okay, so when we talk about evictions, it's probably important to lay the groundwork here and understand, what does the full timeline of the eviction process look like?
All right, I'll jump in here. Okay. In Jefferson County, the law of the land in Jefferson County is something called the Uniform Residential Landlord Tenant Act. And so Louisville, Jefferson County, and some other localities have, in Kentucky, have enacted this. The timeline is different depending on how how the tenant has breached the lease. Okay, so if it's for non-payment, then the landlord has to give a 7-day notice to vacate. if the reason is due to something other than non-payment. The person has unauthorized people living in the apartment, a dog that is not supposed to be there, etc. Then the landlord must give 14 days notice to vacate. And also in that, it's a notice to vacate or to cure, okay? So they can fix it within that time. In that 7 days, they can pay the rent. And the 14 days, they can do something else to try to fix it. Get rid of the dog, get rid of the unauthorized people, write a letter of apology. After the notice period expires, then the landlord may file an eviction action. In Jefferson County, a court date will generally be scheduled 30 days after the filing. Let's assume that both parties show up to the court date, and the tenant says, I want a hearing. Then 14 days after that, a hearing will be scheduled. So from the date of filing of the eviction to having an actual court date or a trial, that's usually going to be 45 days.
Is there a resource people can go to see this process?
To see this whole process, gosh, I can't think of one right now. I'll turn to my other panelists.
I don't know of a timeline. No.
Yeah. Okay. So let's think about that timeline now. I mean, we're in kind of extraordinary circumstances. So where do we stand kind of on the eviction timeline around reopening at this point?
Let's see. Well, right now, Jefferson County has not opened up for evictions yet. The courts reopen on June 15th, and a landlord can file an eviction for any reason that is not due to non-payment. So they can file the one for bad behavior. They can file one for commercial tenants. Those can be filed. We don't know the date yet on which the court is going to reopen evictions for non-payment. There's speculation that that's going to be July 1, but there has been no order yet, so we don't know.
Okay. So thinking about payment, so at what points in the process, this is kind of a multi-question here, at what point can the landlord accept payment? Do landlords have to accept full payments if the lease is still valid? And if there's rent assistance from a third-party vendor, is that considered a subsidy program as well? And if they accept partial payment during the eviction process, do they have to start the eviction process all over again? So those are several questions to consider.
All right.
Can I start with the front end side first, and y'all bring in the legal side of it? Is that okay?
Have at it, Tom.
Sounds good.
Okay. Again, I'm talking from a social services lens at this moment. When a client has contacted us needing this assistance, we're going to ask them what stage are they in the eviction process. The way that I ask that question is, tell me about the notice that you received saying that you're in an eviction right now. Well, I got this letter on the door, and it says that I have 7 days to leave. If I don't pay in 7 days, then I have to get out of here. Can you tell me, is there some sort of any sign that that's a legal document? Did the sheriff put that on your door, or is that from your apartment complex, or is that from your landlord? This is from my landlord. Okay, then stop for just a second. We've got some time to negotiate some things here. We haven't gone to court yet. We're not in that phase yet. We are in the 7-day window. And then in that 7 days, that's when we do that heavy negotiating, figuring out how much do you owe, asking the landlord, can we waive these late fees? And now that we really know how much you owe after we've renegotiated some late fees, we start reaching out to resources. Tell me who you've already contacted. Did you contact your local church? Did you contact one of the area ministries? How much money was pledged in that process? And when I say pledged, I always coach our clients to obtain some sort of letter, understanding there's checks that are coming from different places in these cases. We're piece parting 1 month of rent or 2 months of rent in this case. We need to get some sort of documentation from those entities of how much are they pledging towards your rent, and keep that documentation. That to me looks like checks, that looks like money. And so every time a person or anytime an agency sends some sort of an amount to the landlord, in all the cases we've dealt with, the landlord is perfectly comfortable with accepting that partial payment from that agency, as long as they have some documentation that that information, that money is coming to them. And that's why I always emphasize, get a pledge letter, get some sort of documentation that, yes, you're getting $200 from, from a Sister Visitor Center, and you're getting $500 from Catholic Charities. As long as you have that documentation, and we're working again in that 7-day good negotiating window, the landlord's pretty comfortable with what's going on. If that person receives now the document on the door from the sheriff's office, then there's a couple of things that are about to happen. One, that piece of paper is going to communicate a court date. And that, again, I'm going to segue to the legal folks here in just a moment. They're either being communicated that there's a court date coming up, or they're being communicated that you've missed your court date, or basically the judge has already decided you need to be out of here, and here's your put out date. Once we get to those pieces of paper sticking to the door, things are kind of falling apart for a little bit here. Sometimes, again, this is where landlord mediation comes. If the client has all their money by the time, well, right before we're about to go to court, then in some cases, they will allow them to stay. Again, that's up to the landlord. But in some that, that they may not, especially if it's a habit that this client seems to always fall behind on rent. So again, depending on what stage they are in the process is where we know we could have the most impact from a social services standpoint, because again, once that goes to court, it's out of our hands at that point. And I'll let everyone else talk to whether a landlord can, take a person back to court, those types of things. I've seen those things happen. Again, they try it. Landlords will not accept partial payments unless there's situations where, we're piece parting from agencies. And it's actually to their discretion whether they want to even do that or not. I'll again segue to the legal team for the rest, but that's what things look like from my standpoint.
All right. Well, and Tonia laid it out well. I'll just talk about, at least in Uniform Residential Landlord Tenant Act, within that 7-day window, the landlord has to accept the rent, full payment of the rent. They don't have to accept a partial payment in those 7 days, but they have to accept the full amount. After that 7-day period, landlord does not have to accept money at all. Okay. If after giving notice of the breach and saying, hey, posting the notice and saying, you got 7 days, you got to get out or you got to pay me. If they accept a partial payment, then they have to wait until the next month, okay, before they can post another notice, okay? They've waived their right to evict for that month if they've accepted a partial payment, okay? So they have to wait until the tenant breaches again. Let's see. And then any rent accepted by a landlord, if the landlord is receives money from a third-party agency, such as community ministries, such as Sister Visitor Coalition for the Homeless, or HUD or Section 8, if they accept that, then that's also considered a partial payment, and they've waived their right to evict for that month.
Very good. Thank you, John and Tonia. Let's switch gears a little bit here. When you're talking about code violations for tenants reporting code violations on landlords, what is the process behind that?
I could speak to that from a personal standpoint, actually. Unfortunately, I am a renter. I've been in places that have not been good places to live in. And so I've had to ask a code inspector to check my property. The process that I followed was contacting, and I'm speaking of course, Jefferson County, Louisville Metro, but the process that I was able to follow was contact Metro Services or 311 and request a code inspector come to my property. I was connected to the proper office within 311 and was able to schedule with no problem. When the code inspector came to my property, they did the walkthrough, and they did determine there were some problems, and they reported those problems actually the same day to the property manager to have those things fixed within a certain time frame. And if those things weren't fixed within that time frame, and that time frame was verified by another inspection coming out, if those things weren't fixed within those parameters, of course, that's when they're looking at violations. But again, from personal experience, just contacting Metro government at 311 and requesting a codes inspection, that's what prompted that to happen. So, again, in my situation, I knew that there were things in the apartment that were unsafe. I had things like linoleum was coming up off the floor, and that was a falling hazard, and there weren't any vents in the bathrooms. Those are things that have to be brought up to certain standards, and that's what prompted my call. So, yeah, it was fairly easy from a consumer standpoint. So,
and I think I've used an app before. Are you familiar? Any of you familiar with the app? Yeah, that you can go into this app and take photos of violations and send that off, and that will be submitted as well. I've used that one time before, and it was a pretty simple process to be able to use. So I'll look for that again. I was looking on my phone, and I think I've deleted that app since then, but I'll look for the name of it. We'll get that out to people. So how about letters? So let's talk about how you document these violations. What documents can us in the profession help, especially lawyers, develop to send to their landlords? What letters do they need, and how do they need to send it, I guess, is a good question as well.
The most common letter that we send at Legal Aid to folks is we call it the 1430 letter. It is, landlord, fix this problem in 14 days or else I'm vacating in 30. And we have a letter template that we send to folks that they can just handwrite it in, what they're asking the landlord to do. What we advise people when we're sending that letter template to them is to go complete it, make a copy of it, so you have one for your records, and then you mail it to your landlord, but you have the proof of it. I think that you can send it by regular mail. I don't think it needs to be sent by certified mail. That's my opinion. Sometimes in the law we will send things. I don't know if I want to make sure that somebody wants to get something, I will send it certified and I'll send it regular mail, because sometimes people will not pick up certified mail. But I know if that regular mail does not come back, I know they got it. But sending it by certified mail, if I recall correctly, is not required under the law.
Okay. Other
I
thoughts?
would say also, you know, when it comes to just dealing with your landlord, sending an email is also totally fine, and it has the added benefit of, if you don't have a rejection, you know that they got it, right? And it's something that you also can keep a copy of. That's why our advice is always, whatever you're sending, keep a copy of. And you know, that includes text messages. People ought to be taking screenshots and saving those to the cloud, and you know, keeping emails as well. I think that's another legitimate way to communicate with your landlord.
Okay, we talk about letters. Let's talk a little bit about.
Hold on just 1 second.
Go
Let me
ahead.
just, there may be a requirement for the 1430 letter to be sent via USPS or through the mail system directly. But I'm saying, if it's something just general, I'm going to be late with the rent or something like that, communicating through email is okay.
How about we talk letters for various things. How about a payment plan? Is there a template out there to help structure a payment plan with your landlord?
Not yet, that I know of.
Is that something that you think would be useful for tenants?
I'm told that would be useful for social workers and tenants, and need to work on that.
When we do and my apologies for kind of going in and out. I'm trying to answer Q&A at the same time, so my apologies.
Fine.
As it relates to the landlord mediation work from a social services standpoint, yes, if we've come to some agreement with that landlord, we ask for something in writing, and I usually ask for it in the form of an email. Can you send me an email of that, and so I can print a copy to give to the client I'm working with. And so, you know, we do that out of, you know, good faith and have that documented, of course, but there's no real, to be honest with you, template or rhyme or reason to it. It's just that we've come to an agreement, and let's get that agreement in writing. It's somewhere to keep that for record. And there are some cases where they're willing to do an agreement. I've had one landlord who the tenant fell behind 2 months on rent. Because of a situation that was out of her control. There was a medical issue. She was an exceptional renter up until that point. The landlord did not want to evict her. He was just trying to, you know, get something or negotiate something. So she finally reached out to us for assistance. She did not reach out to her landlord, and that's another issue in itself. A lot of folks will receive these notices and they will not talk to their landlord anymore. And their landlord simply put the notice there because they're forcing you to talk to them. But in this case, you know, just the fact that he said, Tonia, I had no idea that this was even happening. If she had asked me, I wouldn't have even put the 7-day notice on her door. And so in that case, we were able to get in writing that he was willing to spread those 2 months of payments. If you could give me what you can afford, and I'll spread the rest of that across 3 months of rent. And she was fine with that. They came to that agreement. But again, that's another can of worms in itself. A lot of these folks will completely just, you know they can't pay rent, and that's it. They'll just sit there quietly in the apartment, and they won't even go to court or anything, not negotiate or anything, just out of, I think, fear, shame for not being able to pay. But in a lot of cases, if they just said something, the landlord may not have even taken action in a lot of these cases. Yeah, I mean, again, we just collect that information as a courtesy, but there's no template to it. It's just nice to get that stuff in writing if there's been some sort of payment arrangement made.
So if somebody is interested in, you know, landlord mediation, who do they go to, and how can, you know, what are the pros to that and what are the cons to entering a mediation stage?
Good question. Our mediation is really loose. I mean, it's not and when I say at the coalition, I'm a team of, there's 3 people on our team, And our landlord mediation is basically having a conversation. In a lot of these cases, we're finding that this is the first time someone has talked about this rent is past due. So that in itself gives you some leverage. You know, introducing yourself, you know, hi, I'm Tonia with the Coalition for the Homeless. I'm working with one of your tenants who's reached out to us for help. And I'm reaching out to you to see what we can do to help you. Because not only am I here to help this tenant, I'm here to help you as well. Because I understand you need to get paid. And I understand this tenant's having a challenge doing that. So let's meet somewhere in the middle. So I kind of act as a, you know, in a weird, I'll just put the word referee on that. In a lot of cases, I'm doing this in my office with the tenant sitting there, landlord's on the phone on speaker. Sometimes I'll just, you know, have a side conversation with the landlord after speaking with the client. It just all depends. It's case by case, but it's basically having a conversation and speaking on behalf of the tenant, being an advocate for the tenant. And at the same time, you'll need to be an advocate for the landlord as well. And each case is different. There's been situations where a tenant has reached out to us for assistance, and then, you know, we're now in advocate mode and reaching out to the landlord to see if there's any way we can negotiate, just to find out that the tenant has done some damage to the property or they're selling drugs out of the property. And then in that situation, we completely understand what the landlord's saying. Now that we have both sides of what's happening here, we work to help this tenant find another place to stay, you know, or we share with the tenant, hey, this is what we're being told, you know, and if you're saying that this isn't true, then I'm going to connect you to some other resources at this point that may help you from a legal perspective. So, you know, again, case by case, we place ourselves in mediation form, more of a referee or a coach around these things, and an advocate on both sides, of the tenant side and the landlord side. So I hope that makes sense. It's like it says, it's more of a, it's not a formal way of, it's not like you don't need like a special type of skill set for that. It's just understanding your place in that conversation, and getting all the information so that you can have it basically, you know, host a discussion between that tenant and the landlord.
And I want to add, I wish Tonia could represent all of our clients at Legal Aid. But mediation isn't required under the law. A landlord has no obligation to enter into mediation. Right now, the court is, right now, there has been no order from the Jefferson District Court requiring landlords and tenants to enter into mediation. Ben, I know, has done some great advocacy to try and get that in place. We don't know what the Jefferson District Court is going to do at this time. It's our hope that a judge will require mediation. Mediation is can be ordered in other types of cases. It's very commonly ordered in divorce cases, in civil, you know, in civil legal cases where, you know, somebody's suing somebody else for money. It would not surprise me if the Jefferson District Court were to order it, but we don't know yet. And mediation mediation will still be voluntary. Well, an agreement will still be voluntary by the landlord at that point, right? A judge can order people to mediation, and you know, landlord can say, you know, go pound sand. I just want my money and I want this person out.
So do you see any ways to incentivize mediation, or any ways to change the system that would incentivize that?
You know, I mean, the incentive is money. The incentive is there. It's money. I mean, if incentivizing it is, I guess, would be money up front. If the landlord can get some money up front, I imagine they'd be more willing to enter into mediation.
Okay. And let's go back to Tonia here. Can you talk a little bit more about the roles of the intake officers at the Coalition for the Homeless and their eviction diversion team?
Yeah.
And maybe as well as legal aid as well, John.
Sure. At the Coalition for the Homeless, again, this program has been in effect for 2 years. The day I started there is when we started doing this work. And it's actually a model that is being emulated across the country. It differs for each area. We've done some study and we see that prevention and diversion work in a lot of cities work very well. So that was the reason for implementing that here in Louisville. It started with just 2 of us, actually 1.5 of us. We had one person that was part-time and I was the full-timer. And then it's really gotten to a point where we need 3 people full-time to do this work. Not only are we doing this work with individuals, but with families as well. Our work includes, like I said, landlord mediation when a person approaches us requiring or requesting help with rent, and I'll talk about what that request looks like in a second. So not only landlord mediation, but also, and there's some cases where we have to do housing navigation, where if a situation where, yes, we're going to have to move, let's talk about what that looks like. Then we have to try to find another place to live. We've got some landlords that work with us around kind of a second chance type of leasing arrangements. If we're providing, since we're providing that case management to that individual or that family, they're more willing to work with a family that we send to them to try to lease, or even we do some assistance in some cases with deposit or first month's rent in those unique situations. So again, each case is different. Mediation is important. The housing navigation is a key thing that we perform as well as, you know, if we have to look at the other side of things, diversion or going into the shelter system. So we navigate those pieces as well. So in a nutshell, that's what we do in prevention and diversion here at the Coalition for the Homeless here in Louisville. Again, this model is not one that's in every city in this country. It's not in every city in this state. To my knowledge, I think we're the only prevention diversion program in the state, if I'm not mistaken. I don't know of any others at this time. But again, this is a program that was put into place. It's actually part of the, I believe we're actually under an ESG grant. So we are HUD regulated. We have to input our information in a system called HMIS. If people are familiar with that, we have to collect that data as part of our intake process. And we have to track, you know, people at point of entry, you know, what their income, how much are they making, if any, the size of their households. So we start to track them in the homeless database system as part of that process. So yeah, it's actually, in my mind, it looks really big and it's hard to put it in words, but that's what we do in a nutshell. So let me kind of backtrack again with the rent assistance for a moment. Our rent assistance is not what I term as the mainstream rent assistance. When I say mainstream, if I live in 40210, I know to call my ministry and see if I can get assistance with rent. I can only do that. I can only reach out to those mainstream services typically once every 12 months. It's every so often when I need that emergency help, I can reach out to some of those places, whether it be one of our community ministries or whether it be a neighborhood place, any of those services that have been established. If you contact or do some sort of Googling looking for help with rent, those are the mainstream services that people normally access. Our organization and others like ours are the people who fall through the cracks, or the backup plan. So in our backup plan in the coalition, what that looks like is if this individual or family is in danger of going back to homelessness, because we've been tracking a lot of activity of people. So if we find that this was someone who was homeless recently and they're in danger of going back to homelessness, then more than likely we're going to do what we can to assist them with their rent after we've exhausted all other resources we're going to do what we can internally to assist them with rent. And we work with donors to get those monies together to help them with that. If this client has a voucher, Section 8, rapid rehousing, permanent supportive housing, any type of special housing voucher that they're in danger of losing, at the coalition, we will assist with rent for that situation. What we try to focus on at the coalition, again, we're not a mainstream, call them and they'll help you with rent. Nope. We're going to ask them some questions to see if they've reached out to all those other resources first. And also we're going to have to look at what are these people that we're talking with high risk for homelessness. And in all the cases where we've assisted folks, they just got out of homelessness. This was their first apartment after being homeless for a while. They're about to lose a Section 8 voucher, so we have to now negotiate with Section 8 to make sure that once we pay this rent, that keeps their voucher active. We can't lose that affordable housing. And then also in the cases of rapid rehousing as well. So, sorry for the background noise. So that's what we do at the Coalition for the Homeless. I know that was a lot, and I don't want people just sending people to us, hey, they'll help you with rent. In actuality, we are the only place to go to if there's those special cases and after everything else has been exhausted. There's another program in Louisville that's similar. If you Google eviction prevention, you may see references to a program that's located at, I'm so sorry, y'all. References to a program that's located at Volunteers of America. That particular program at Volunteers of America is exclusively for people who are residents in Louisville Metro Housing Authority properties. So if someone needs help with paying their rent and they live in a Louisville Metro Housing Authority property, they would call Volunteers of America, and there's a particular person that helps them with that there. And then in our case, if it's a situation where, again, we're in danger of losing some sort of housing programming, or if they've been in homelessness before, then we're the people to reach out for that. But otherwise, everyone should continue to utilize their mainstream resources. Hope that makes sense. I know that was a lot to say in a short amount of time.
Thank you.
If anybody has any questions about that, you can reach me.
Mm-hmm. And John, for legal aid?
At legal aid, so people can reach us in a number of ways. Right now, it's through telephone or online application during normal times, right? People can also walk in and complete a paper application. If somebody has, if it's somebody who's non-English speaking, or if it's a very elderly person, and they've walked in, then they may see a live person there just because, they have a barrier. And so usually it'll be me that will go and see the walk-in in those cases. Our intake paralegals, they will screen for income eligibility. So that's below 200% of the federal poverty guideline based on household size. Asset eligibility, generally that is less than $8,000 in assets. We will ask about citizenship or whether the person has a legal immigration status, and we can help people who are undocumented if they're a victim of domestic violence or human trafficking. And so the intake paralegal will do the initial screen, get an idea of what the problem is, and then the case will be routed to an attorney. An attorney, they're going to look at things like whether there's a defense to the eviction, such as if the notice is bad on it. We'll also just look at the tenant's goals, whether they actually want to stay in the place or if they want to move out in a certain period of time, and maybe the attorney can negotiate a a way for the person to move out without having an eviction on their credit report. And also see, and then the attorney may also see whether the person can enter into a payment plan and figure out figure out if there are some community resources. I think pre-COVID-19, there is no defense to non-payment, and there still is no legal defense. But now we're going to start looking at non-payment cases and take them and see if we can figure out resources for people. Other things that we'll look at is whether the landlord-tenant relationship, whether it's too broken to be fixed. If it's just so far gone, then maybe it's just better for the person to move out, and we just try and keep the eviction off of their record. Also the person, if a tenant moves out before the eviction date, moving out means get themselves out, get all of their property out too. Then we advise the people, show up to the court date and tell the judge, I have left. I have gotten all of my stuff out. The judge may have them swear under oath that they have left and they've gotten all their stuff out. And then the judge will usually dismiss the eviction case.
Okay, this might be a good segue here. So we all live in this box that is, trying to do it with my hands here, the Zoom box. So some courts are doing Zoom court or doing remote court proceedings. How do you show up for that? How do you make that happen? And does it make a difference if the tenant shows up for that court hearing?
All right. Well, I'll just talk about what the Jefferson District Court is doing, and I'm not going to comment on what they're doing. I'll leave that to Ben Carter. The process with each eviction or forcible detainer complaint, that is the technical name for the eviction papers that the sheriff will be serving upon people, there's going to be a notice. All right. And here, I'll share that notice. Let's see if I can do this here. Share. All right. And so this notice is going to be inserted into or delivered along with every forcible detainer complaint, and the individual can participate by video, assuming the person can do that, or they can participate by phone. And so the forcible detainer complaint is going to say that, give a date and time. You see there that it says that if you don't have a reliable phone or computer, then you could email this number. But that is how they are doing it. And I will.
Do you have commentary, Ben?
Always. John, can you post that to the chat? I don't think I've seen that yet. Yeah, I mean, I think the question about Zoom technology or remote hearings is a tricky one, because on the one hand, for a certain kind of renter or Kentuckian who rents facing eviction, appearing remotely is going to be more convenient, and they might be able to contest it in a way that they otherwise would not be able to take off work or be willing to take off work to come down to Jefferson District Court. So on the one hand, the court may be opening itself up to additional volume by offering these remote hearings. The problem for a lot of the folks who I see in the chat and where you work is your clients are not going to have access to a Zoom account or technology that allows them to appear via teleconference. And I certainly don't want our clients to be in a situation where on a Zoom call, they're a black box and the landlord's attorney is there in a coat and tie in the Zoom box talking about, evicting this person. I just don't think that that's a fair position to put people in, and it has constitutional implications. I mean, the court is in a real pickle right now because doing something remotely is not fair to certain litigants, and doing things in person is not safe. And so that's why this rush back to the eviction process, I think, is exactly that. It's a rush, and we could have taken a few more weeks to sort this out, to get remote locations set up, to allow legal aids to get processes in place, to ramp up these efforts. But that's not where we're at right now. And I'll just say, the notice that John shared is different than the other 119 counties that are going out. So if you have people in other counties, it's not going to be that process. Some courts are using Skype. Some people are requiring people to show up in person and go into the courthouse and check in with the bailiff, and then go out to their cars and call in to the court from their cell phone in their car in the courthouse parking lot. And so it's just a lot right now, and there's no uniformity to the process. Hopefully we can get there.
Okay, thanks. So I just wanted to remind everybody, the Q&A has been very lively, so has the chat. So we're going to save like the last 15 minutes for Q&A from you, so please use that function to send questions. A lot of questions have already been answered by panelists, so thank you for keeping track of that. So the last question I have, it's probably geared towards Tonia, is about rent and utility assistance. We can't talk about evictions without talking about the importance of utilities, especially. Where can these assistants, where can you find a list for assistance and keep updated on new types of assistance that are available?
That's a very good question, because there's a lot of different things out there. Again, most of the people on this call are probably familiar with those mainstream resources. Again, that's your local community ministries, depending on your zip code. Also, the neighborhood place locations. Neighborhood place locations, just wanted to remind folks that the assistance provided there, they're going to go through, of course, some income verification, making sure they're within certain thresholds there, but also in the cases as far as rent assistance is concerned, they had to have lost a job or lost hours on a job before they can assist with rent. And there's a certain equation around that. I can't recall off the top of my head, but that information can be found on the website for the neighborhood place locations. So those are the two mainstream places you can get some assistance. We also recommend the things that are off the beaten path. I do ask clients if they're a member of a particular faith-based organization. There is a benevolence fund that may be able to assist there. So you have to be kind of creative in where to find assistance. One thing that I also want to remind folks is LIHEAP. And of course, most folks on this call probably know what LIHEAP stands for. I know that in most cases, it seems as if LIHEAP is a seasonal thing. It's only available during the winter months. But in actuality, after those seasonal periods close, there may be still some resources you can take advantage of, still offered through LIHEAP. They do have hardship programming. They do have help people who are trying to move into new places, but they have old LG&E debt outstanding, making it so that they cannot turn on their utilities in the new place. So those resources are still available, even outside of the regular time frame that you would know LIHEAP to operate in. There are some other funds as well. I'm sorry, my dog. I'm so sorry. They're also, he's mad at somebody. I think my husband's coming home. I'm so sorry. There are some other resources that are available. FEMA, of course, is providing resources, as well as Team Kentucky Fund, Esperanza Fund. I think Claire is more versed in those, and she's got a list that she maintains as well. We at the coalition are providing or creating a directory on our website. Hopefully that will be up and live soon, with all the links that you can find and where to go to get assistance with rent and with utilities. So sorry. His name is Happy, everybody. Believe it or not, he's happy. So there are so many, again, those mainstream resources. There's the resources that are outside of the box. And of course, you can always contact the Coalition for the Homeless if you need any assistance in finding resources at all. I've put our phone number in the chat. Hopefully everybody gets that. That's the same number that you would call for bed reservations and shelter, but it is the 502-637-2337. We can assist, as well as the 211, which is Metro United Way's number that's available 24/7 to locate local community resources as well. So if anybody reached 211, call the coalition, reach out to their local ministries. They can find the resources they need to get rent assistance and assistance with utilities as well. LG&E, again, never forget to reach out to LIHEAP no matter what time of year, because there's some hardship resources that are available there even after season. Again, look outside the box. There's other grassroots types of organizations. We've gotten assistance before through Black Lives Matter. We've gotten assistance before through some smaller neighborhood churches in the areas. So, never hesitate to ask your client a little bit more about, their surroundings or their environment, because there's probably some ways to get some assistance there as well. I think you're muted, Tony.
Thank you. Everybody does that, right? There is a question in the Q&A for Tonia. Do you all help those in prevention and diversion for those who do not have social security numbers?
Very good question. And when you say those who do not have social security numbers, I bucket that in two different ways. So people who have lost all their identification for whatever reason, typically our homeless clients, they do not have a social security card, they don't have a state ID. Yes, we can assist in obtaining those documents again. Of course, in the coalition, we are a coalition of many organizations, including there are 2 day shelters, Up for Women and Children and St. John Center for Men. They assist in obtaining those lost documents. So when you say no social security number, as it relates to lost documents, there's some assistance with that. If a person is undocumented, they do not have a social security number for that reason. We do have challenges finding housing for people that are classed in that way. As far as shelter is concerned, for emergency shelter, yes, they can still enter emergency shelter without a social security number. That's never an issue. It's just locating or connecting to housing. Unfortunately, our access to housing is mainstream. So it's HUD, it's everything around, what is required there. If there is a family and, one person is missing a social security number, but the other one has a social security number, we may be able to access a few types of resources there around housing, typically public housing. But otherwise, it's pretty hard for someone who's undocumented to navigate in the systems that we have access to within the coalition. We do partner with La Casita Center, as well as other organizations, for assistance around navigating outside of these systems that have been created to keep people out. Yes, everything, yes. If anybody has any questions or has problems in trying to navigate these systems without a social security number, they can definitely reach out to us. If it's a matter of us replacing documents, we can help, or even if it's a matter of us trying to figure out where to go next as an undocumented person, then we can reach out to some partners for that too.
Thank you, Tonia.
Mm-hmm.
There's another question from Lynette. This might be towards John. So if a judge dismisses eviction when a person leaves without payment, does that mean there is no eviction on the record, and hence they won't have such a hard time locating housing?
So there won't be an eviction judgment on in the court record. There will still be a record of an eviction having been filed. And so I would hope that the next landlord can recognize that the eviction was dismissed, but it doesn't erase, it doesn't erase that an eviction having been filed. But it's better, right? It's better to have that you can say, look, new landlord, the case was dismissed. I was never evicted from this place. I'm a great tenant. And that was a misunderstanding, right?
Okay. And I think Ben brought up a point in chat over here about asking for a trial. Let's talk a little bit about that. Should tenants who go to eviction court ask for trials, and are they likely to get that granted to them?
That was sort of a chat thing. I'm not sure we really need to delve into it, but it's just I'm concerned that, I mean, we know the district courts aren't doing trials until August 1st, and so it seems like the notice that John posted suggested that people were expected to be ready to go to trial or have a hearing with all of their evidence on the date of their first hearing, which suggests that courts aren't going to look for requests for trials with a lot of generosity. So, and to be clear, we are in a situation right now where landlords can only evict people for reasons other than non-payment of rent. And so whether someone is in violation of that lease, usually whether you paid rent or not is an open and shut case. Either you paid or you haven't, right? Maybe you paid with cash and the landlord says you didn't, but for the most part, that's an open and shut thing. Whether someone is otherwise in violation of a lease agreement is a fact-specific question, or can be. And so in most situations when a renter isn't requesting a trial, there's not really anything much to try. But here, there are going to be a lot of facts that require or would suggest a trial would be appropriate at times. And logistically, we come up with a lot of questions about resources and whether we have enough attorneys to do all of that work, and whether it's in the client's best interest and all of that. And that's, those are individual determinations. It was just a broader, observation that it doesn't seem like the court is going to want to grant a lot of trials if they're expecting people to show up to a Zoom conference with all of their evidence in hand at that time. So, I think one of the things I wanted to say before we logged off was, someone had asked from, I think, the Phoenix Health Center or Family Health Center, have landlords started sending out that 15-day notice? And my point was, for a lot of these landlords, because the court only changed the rules a few days before opening up courts on June 1st, they wouldn't have known to send out that notice alleging a non-rent repayment lease violation or a non-rent payment lease violation. And so frontline workers should really start looking for those kinds of notices coming soon. This is my toddler pounding on the door.
Well, that probably shows that we're
not happy.
That probably shows us that we need to think about wrapping this up. So any additional comments from Tonia or John before we wrap up today?
I think I'm good. I've put my contact information in the chat. Forgive me if I missed someone's question. Again, if you need to reach me, you can contact us there. And, again, all those resources are available. They're tricky to navigate sometimes. If anybody needs an assistance with anything at all, even, navigating some of those pieces, just, let us know. We'll be glad to help.
One thing I was going to say is we've been talking a lot about evictions that are coming down the pipe right now for reasons other than non-payment of rent. one thing to flag for everyone is that we don't know when the court is going to start allowing evictions for non-payment of rent. We know that CARES Act landlords can't start filing those until August 24th because they have to provide 30 days notice that they can't provide until July 25th to start processing those. But the court has said, as long as Andy Bashir says we can't process evictions for non-payment of rent, that's how long we will do it. And Andy Bashir hasn't said how long he's going to enforce his eviction suspension for non-payment of rent. So we have a letter that we're drafting that we're going to ask every organization on this call to sign on to ask Governor Bashir to promise that he will not start evictions for non-payment of rent until at least August 24th. But if at that time he can't look at Kentuckians and say there's not going to be a single Kentuckian that faces eviction because of unemployment insurance problems, that he needs to extend it until he can say to Kentuckians, anybody who's facing eviction now, it's not because our unemployment insurance system is delayed or broken.
Very good. Well, unless there are additional comments, John, do you have anything else?
No, thank you for hosting this. Thank you to Ben. Thank you for Tonia. You all were great.
Yeah. Thank you to everybody who attended today, and to Tonia and Ben and John for sitting on the panel today. We are recording this, so we'll hope to make it available to a broader audience soon. And we thank you for your participation, and everybody have a good evening.
Thank you all.